session. Please be seated. Good morning again. This is a continuation of the April 3rd, 2024 sitting of the Massachusetts Appeals Court. The record will reflect the panel now consists of, to my right, Justice Brennan, to my left, Justice Toone, and I'm Justice Eric Neyman. Calling our second case, docket 23P 542, Commonwealth versus ZORRILLA. Attorney Gleason.
Thank you, Your Honor. Good morning.
Morning.
Judges, as you've seen from the record, this is a case that the evidence took not much more than half a day to present. It was completed in one day other than argument and charge, and consisted of 3 witnesses who testified. I think that's fundamental to an analysis of the case and our argument that we're making. Number one, with regards to ineffective assistance of counsel, the fact that there were, in particular, 2 of the 3 jurors that I've raised, 2 of them, one was the United States Marshal. The United States Marshal was not immediately known, had actually had lunch with a member of the District Attorney's Office, and when it came to light, it's important to note that it was challenged for cause by trial counsel at the time. It was challenged for cause, but not peremptorily. Number 2, the sexual assault victim juror also was challenged for cause, and what I think is noteworthy about that is that she herself was, certainly not sure that she would be able to be impartial, and struggled somewhat with her responses in that regard. And when it comes to both of those in a rape case, and in particular a rape case where I would suggest was a weak one for the Commonwealth, I think that would be supported by the fact that for barely a half a day of evidence, there were 2 days of deliberation before a verdict was reached.
The juror who was a sexual assault victim was an alternate, correct?
That is correct. That is correct. But what that raises, though, Judge, and I've mentioned it in my brief, is the fact
footnote 4.
Yeah,
yep.
That, even though she was an alternate, the fact that the matter remains, somebody else might have been in that spot, and once the cards get jumbled, who knows what's going to happen with what. I just don't know. And
what does our case? I'm sorry. What does our case law say about that? I think it's not enough just to say that the cards are jumbled, right? You need to show a little bit more than that.
Well, again, I agree. In order for you, if I was asking you to rest your conclusion just on that, it wouldn't be enough. But the point that I'm making is that, in something that's so important, counsel even mentioned himself that it's as a life, because he did that with the sexual assault victim. He mentioned in that it would be prudent for him to challenge for cause, and he didn't peremptorily. And also having, so you got 2, and again, all of them gave the right answers, and again, this is just a piece of what I'm here for today. They gave the right answers, but I certainly, defense counsel, generally speaking, don't want to have police officers or federal officers and sexual assault victims on, as a general rule, on a rape case. And
can I ask, Mr. Gleason, I think you alluded to it before, but when you talk about you don't know who's going to come up next, doesn't that cut both ways? And isn't that always part of the calculus of the trial lawyers? We don't know who the next 3 or 4 jurors that the defendant and trial counsel are looking at might have been, right?
Yes, and there's no question. I'm not going to rest my argument there. And quite frankly, I was debating whether even to talk about it because of the fact I do think that, but it has to be, because when it all ties together, I believe that there is just a cumulative effect to all of this that transpired and happened in such a short period of time.
And just to follow that, in his affidavit, the trial attorney said it was a choice. I mean, he chose it as opposed to, so that would imply at least some level of strategic decision-making, right?
Yeah, and that's, so he was thinking strategy. Right. again, if it's strategy to have essentially two law enforcement officers and a sexual assault victim, again, if it were just one, that's one thing. But this could have comprised 25% of the deliberating jury. And again, if that's his strategy, then I can't comment on that, quite frankly, in a manner with which I would agree with. Having said that, also, it bodes with regards to that it doesn't appear that there was, certainly there wasn't any defense presented, doesn't appear to have been any significant, there certainly were no notes presented, that there had been an investigation that included notes and talking to witnesses, and there were people out there, Joshua, Pamela Padilla before, because of the later issue with regards to what she remembered or didn't remember. The women who were the voices, the women who were at Manchester Street before and after the return. And, so there's a lot of stuff that could have been done, and that again is something that counsel might question when, particularly as he indicated, he's looking at a potential life penalty. But in particular, the first complaint witness gets up on the witness stand and 3 times consecutively said, "I don't remember." Now,
Can I ask you this, because it was an interesting point, and I'm going to look back. The prosecutor didn't ask leading questions, though, in response to that, did she?
pardon me?
In response to the witness saying, well, I don't really remember, or my memory's not very good, or whatever I'm paraphrasing.
Yes.
The prosecutor did not ask leading questions in response to that, which might have been a little more problematic.
Yeah, but I do suggest, Your Honor, that what should have happened, when you get to the third answer consecutively and the specific purpose, because the first answer that she gave was relative to something that wasn't words that were spoken, but information that she knew of, because she had left with other individuals, and she's not there to be a precipient witness. She's there as a first complaint witness. Now, but in addition, at that moment, and again, in the cumulative effect, I don't disagree with Your Honor, but at the very least, after the third consecutive answer of saying, "I don't know," in essence, and I'm paraphrasing, "I don't know, no, I don't remember, and yes, it is true, I don't remember," to the leading question, the third question, there wasn't an objection. Now,
So hypothetically, would it have been objectionable, for example, when she says, "I don't remember very well," or "I don't remember," if the prosecutor just walked up with her statement and refreshed her recollection from it?
yeah, there were other things that could have happened, for sure. But again, the point I'm making...
So when the prosecutor, says, "Well, why don't you tell us what you do remember?" What would be the basis of any objection to that question?
None.
Okay.
But what should have happened, and again, on the issue of my questioning, because Your Honor raised the issue of strategy, part of a strategy. Well, I don't know what the strategy might be when those answers come out and that there's not an objection made. And I just don't know. So again, I'm going to get to the cumulative effect. And again, I put it in with regards to the erroneous instruction, which is creating an image, and there was no objection to it with regards to the use of the words of actual crime and a sexual assault, as if that's what it was. Because what the government has to prove, of course, beyond reasonable doubt, is that there actually was a sexual assault. But also, all of it ties together, I would suggest, in this very short trial, which again I would suggest, was a weak government case, relatively speaking, where there's a he said, she said, there's no physical evidence, there's no eyewitness, and there's an explanation of why it might be, what might be the bias or motivation for it. Having said all of that, the critical issue in the case is, how do we get around the fact that in a situation, and I know that at the time of the motion for new trial, The Commonwealth versus King was mentioned, and as if that were a cure-all. It's not. And quite frankly, I would suggest it's not even close. That certainly, if you just look at the labels, you look at the labels, and the labels are rape and armed robbery. Okay, are the labels the same? The answer is yes. However, when you talk about the allegation of rape in King was certainly, I put it in my brief, there's no weapon, but there was also not just no weapon involved in King, it involved a 4-year-old with somebody, but there was no overt any kind of violent act or anything else. So that is, again, is it the same label, rape and armed robbery? Yeah, it's the same. But in this case, and so the dissimilarity, they're considering, it's in this case, there's a weapon. And it's not just a weapon. There's an issue. He grabbed her by the arm, grabbed by the chain, got up twice, brandished a weapon. Grabbed her by the head, pulled it down. There are these acts of violence, and also there is a weapon. This is entirely dissimilar. And the judge himself, I think it's important, not only did counsel say, with regards to, it's the prudent thing to make a challenge for cause and then not do it, the judge himself commented in his decision that, and if I may, well, without specifically saying it, he talked about, he addressed the issue that was being raised by counsel, saying, look, the fact of the matter is, in his final statement, his final sentence, he talks about, well, it is sufficient. There's an issue with regards to the weapon, but I'll cure that because I'm not going to let you talk about what kind of a weapon it was in the armed robbery. And just to be specific with regards to what I can read it, because I don't want to misquote, but is that it really is not similar at all to the sexual assault at issue in this case. Again, when sanitizing the specific weapon that was used, which is not going to be brought out, so that's my ruling, as if to say, well, there wasn't a specific weapon in the impeachable use of the conviction of armed robbery, that it's distinguishable. It's not. When ordinary folk go into a jury room, what is it that they're going to be thinking? They're going to be thinking, here is a crime, alleged, the rape in this case. Here's a crime where there's violent conduct, brandishing of a weapon, grabbing, physical contact, pulling head down, grabbing by the necklace, and all that. And the guy's charged with an armed robbery. And there's use of a weapon, and oh, by the way, there's a weapon here. It is the same. And what are they going to do? This guy is capable of violence. This is a violent guy. So now 2 full days later, what are they thinking about? Where do they end up in the room? Someone testifies, she's obviously got contradictory statements, and that's, ordinary humans are going to be thinking what? Well, she's 16 years old at the time. She's not going to get everything right. I mean, but that can't be the entire defense. Getting back to strategy, if you got a different strategy about everything, where is the defense? Is it just that her statements are inconsistent? Because when a jury analyzes a case, and well, we got a 60, well, she wasn't totally consistent, and oh, by the way, they did ask for Pamela Padilla's testimony the next day when they began the second day, so they had concerns, and they went through the balance of the day. So, in fact, they're concerned, they're struggling, and where do you end up? After you get through, well, yeah, this and that. And I know the instruction is given, but the reality is the defense presented nothing. They said, don't allow it bring you to, in essence, where we're left with. And why? Isn't it fair to assume, and isn't it reasonable that, in fact, in a case like that, the strategy is I'm putting my guy up there, and he's either going to say it didn't happen, or, by the way, it was by consent. And it was there. It's a weak case. They don't have any physical evidence. It's not like the last case I heard about where evidence was overwhelming, or if I heard it correctly, I don't mean to be misquoting anything. But the fact of the matter is that it wasn't.
Are you making, in terms of the prior conviction, which would have been admitted in, are you making the argument that any time someone is on trial for aggravated rape, as a matter of law, a prior conviction for armed robbery cannot be admitted to impeach?
No. What makes it, I'm not making that argument.
Okay.
What I am making is, though, in particular in this case.
But the facts of the underlying armed robbery would not be allowed in
Correct,
no matter what.
Correct. Correct. But when a jury here, and what I'm just drawing the distinction with King. In this case, they're only going to hear it's an armed robbery. We all know what armed means. I assume any reasonably knowledgeable, intelligent adult who's sitting on a jury is going to know he had a weapon.
So you're making the argument that any time there is an aggravated rape being tried that involves the use of a dangerous weapon, that a prior conviction for armed robbery is inadmissible to impeach?
No, and I don't think you have to go there, because they already had the larceny by false pretense in. If the robbery component is being used for purposes of challenging the credibility, they already had that in this case. That's the part that just can't be answered. The fact of the matter is, they've already got the larceny by false pretense. It's in. We're not disputing that. I'm not saying here you can't be used. And there may be, to answer your question, Judge, circumstances where, of course, it can be used in other situations. But here they've already got the attack on, and therefore the analysis in terms of what must be used is the prejudicial effect outweigh any probative value?
I understand.
They had the probative value. And this in a case that's weak, not a slam dunk, and this and that, this is a perfect opportunity for a defendant to get up there. How's he?
Anything further? No, anything further? No, I'm sorry, but you're 2 minutes over time.
Thank you.
I understand your argument.
Appreciate
We
your
understand
time.
your
Thank you.
argument. Thank you, counsel. Attorney Burns.
Thank you. Good morning, Your Honors. May it please the Court, Kayla Burns for the Commonwealth. Commonwealth asked this Court to affirm the denial of the defendant's motion for a new trial and affirm his conviction of rape. I'll begin with the ineffective assistance of counsel claims, and first and foremost, the judge acted well within his discretion in denying the motion on this basis. And I'll start with the peremptory challenges issues. And first and most importantly, I think, the defendant has not established in any way that he was prejudiced by counsel's failure to exercise a peremptory to any one of these three jurors in question. First and foremost, the juror who was a victim of a sexual assault, she did serve as an alternate in this case. So I think that alone ends the question of whether the defendant was prejudiced as to that juror in particular.
Let me ask you a question about that. Volume 1, page 143, the juror who was a victim of sexual assault was asked if, in light of her prior experience, she could put aside, would that affect her ability to weigh the evidence in this case and be fair to both sides in doing so? Her response was, at least initially, she was unsure. My understanding of the law on this issue is that there must be an unequivocal response that indicates, unequivocally, that the juror is able to be fair and impartial. I'm unsure is less than unequivocal. So why was that juror not struck for cause?
Well, respectfully, Your Honor, I believe I have the exact quotes here, and the first question that was posed to this juror, do you feel as though that your experience would affect your ability to weigh the evidence? She says in response...
And be fair to both sides in doing so.
Correct. And then in response, she says, see, I don't believe that, or I'd like to think that I could be impartial. I just want things to work out the way that they should. I would hope that I would play a good part in that, but I'm unsure. I can't speak on anything I'm not, experiencing.
That doesn't sound unequivocal to me.
Respectfully, Your Honor, I believe the judge did have reason to continue questioning this juror, and I think that that answer, looking at it as a whole, does indicate that she believes that she could be impartial, and I think she later clarifies that her concern is that she's not actually experiencing it in the moment. But I think she
It doesn't sound
does.
unequivocal to me. I don't take issue necessarily with what the judge here, I take the issue with the standard, frankly. I don't know of anything that is unequivocal in the law, but that's the standard the SJC has given us. So I don't know how trial judges can, on a practical level, actually comply with that. I think it's frankly unrealistic. But it's the standard we've been given. And if that's the standard, it seems to me this juror should have been stricken for cause.
And certainly, if that is the standard the court is looking at, which it is in this case, I do think her later answers become unequivocal. I think that the questioning does indicate that later, she does indicate, and a later question that the court asks.
Go ahead.
Oh, sorry. I didn't know if that was a question. A later question asked by the judge, I believe still on page 144, would you be able to listen to the testimony and weigh that testimony in a way that's fair to both the defendant and the district attorney? Yes. And I believe even defense counsel asked a question that the juror later says that she would be able to put aside, or excuse me, this is a question by the assistant district attorney. Do you think you would be able to put your prior incident aside when listening to the evidence? Yes. And I think perhaps viewing her first answer only in a silo, perhaps that would be viewed as unequivocal. But I think it's important to look at everything she said. And I think the judge does flesh out that she is able to be impartial. And I think the judge later expresses that based on these answers, that certainly not every juror is going to know what their reaction is to testimony coming in, but he had a belief that this juror was going to be able to be impartial. So I think it's important to look at her entire answer, and certainly looking at that first portion, perhaps it would be appropriate if she had been struck, if that's all she had said, but I think we have to look at everything that she said, and I think that the rest of her answers show that she was able to be impartial.
Given that it seemed that, at the very least, a close call on whether she should have been struck, how are we supposed to assess the failure of the defense lawyer to exercise peremptory on this? I understand peremptory is a classic strategic judgment. You know, you have a very difficult standard, but when you have a compelling case to strike the juror for cause and then don't exercise peremptory after that, what kind of strategic judgment is that? So I'm just trying to understand how we look at that issue.
Certainly, and I believe this issue is not addressed in trial counsel's affidavit. I believe he only talks about the juror who had lunch with the district attorney's, member of the district attorney's office. But I do believe that in the transcript, counsel does take a moment to confer with the defendant at that point, takes a moment to discuss with him, presumably.
So we all probably know that that's what's happening. And I read that, and on a couple of occasions, I may have a moment. And I think anybody who's tried a case knows what he's doing is going back and checking with his client, right? But that's not really clear in the record, nor does the judge make a finding, nor does the defense attorney, the trial attorney state, give me a moment so I can check with my client. So how do we know if that's what's going on as opposed to the attorney just saying,
Certainly, we can't know for sure. It's not reflected in the record, as Your Honor pointed out. It is not in defense counsel's affidavit. But I think it's safe to assume that that's what was happening. And then after defense counsel asks, may I have a moment, he does indicate to the court that the defense is content with having that juror sat on the jury at that point. So certainly, I think the record doesn't make entirely clear that that's exactly what defense counsel was doing, but I think it's safe to assume that he was conferring with his client at that point. After that conference, he did represent to the court that he was content with having that juror on the jury at that point.
I tried to figure it out from the record, I couldn't, but it seemed pretty clear that the defendant was not, whether they did it the sidebar, I'm not sure, in the individual voir dire, where they bring the jurors in one at a time into the courtroom, but
I don't think the record is entirely clear. I can't remember for sure. I think defendant says something about it in his affidavit, but I don't think the transcript makes clear as to where everyone was positioned at that time. But again, I think it's safe to assume that when defense counsel asked for a moment that he was conferring with his client at that point. And then moving on to the other two jurors in question here, particularly with the retired U.S. Marshal who had lunch with the District Attorney's Office employee. At that point, and I think it's clear in defense counsel's affidavit or trial counsel's affidavit that he did make a consideration on this juror in particular as to allowing or not exercising a peremptory in this case. And I think that's important for this court to look to. And then finally, as the DHS employee, employment alone is not a basis to challenge, certainly for cause. And I think where it's not a basis for cause, I think there certainly could have been other reasons for this individual, for defense counsel to not exercise the peremptory. So I think certainly the defendant in no way has shown that he was prejudiced by, and even especially with the victim of the sexual assault, where that juror in particular did serve as the alternate, which I think is very important in this case, especially where it appears that it was a close call whether this juror should have been struck for cause, but she did not participate in the deliberation in this case. So I think that's very important in this case as well. And moving on to the next claim as to essentially the investigation of the case here, I think it's very important to note that defense counsel did put on a robust defense for this defendant, even though there were no witnesses called. I think it's important for the court to note that defense counsel did conduct an extensive cross-examination as to the credibility of the victim in this case, and did forcefully argue to the jury his theory of the case, that this victim had reason to lie and fabricate her claim of the rape because she was upset with what she did with the defendant in light of her feelings for someone else.
Was there an affidavit of the investigator submitted with the motion for new trial?
There was not, Your Honor, just trial counsel's affidavit who says that he hired one,
Right.
And that this investigator did interview witnesses that were listed in the report.
Did the defendant's affidavit explain what witnesses existed that the investigator should have spoken with, what information they had, or what they could have testified to?
Did not, Your Honor, and I think that's a very important fact in this case. The defendant merely says that he provided a list of witnesses to defense counsel for the investigator to question, which trial counsel disputes having that list provided to him by the defendant. But the defendant's affidavit includes no information as to who these witnesses might be and what any possible testimony they might have provided was. And I think that's very important to remember here, because the defendant it's defendant's burden to put forward how this evidence would have made a difference in his case, and he has not done so here, particularly in light of the fact that we have no idea what these witnesses may have said and how it would have been beneficial to this defendant. And next, going to the first complaint testimony, Pamela did properly testify as the first complaint witness in this case. And I think, again, this is another case of where if we look at this witness's first statement, perhaps it would appear that she did not remember. But I think it's important that we look at her testimony as a whole and look at the questions that were posed to her before she responded. And I can't remember verbatim, but I believe the first question that the district attorney poses to Pamela is something along the lines of, what were the words that the victim said to you that day? And that's when Pamela responds that she doesn't remember. And I think it's safe to assume that her response that she didn't remember at that point was because she didn't remember the exact words that the victim said to her at that point, not the substance of what the victim then conveyed to her. And I think that's made plainly clear when you look at the whole of Pamela's testimony, that maybe she doesn't remember the particular words that the victim said, but she does remember that the victim came in, was upset, and told her that someone had basically threatened her to commit oral sex on them. So I think it's important, again, that we not look at testimony in a silo here. And I suppose I'll just briefly touch on the first complaint instruction. I think that the defendant in no way has met his burden to show that this was anything more than a slip of the tongue by the judge at this point. And I think it's very important that the court focus on the fact that this was the first of 3 first complaint instructions, and both the second and the third instructions were exactly how the defendant proposed that the first one should have been given, and those were the last 2 heard by the jury. And finally, as to the prior armed robbery conviction, the judge again acted well within his discretion in allowing the Commonwealth to impeach the defendant with this prior conviction. And I think the case law makes very clear that armed robbery and rape are in no way substantially similar. Just the fact that there was a knife involved in both of these offenses in no way rises to the level that would create a substantial similarity between these two crimes. And I think that's especially important here because—
The jury would not be told, if the impeachment were allowed, the jury would not be told that the prior armed robbery was with a knife.
That's correct,
So
Your
the
Honor.
similarity of the facts is not an issue, is my understanding of the law. The jury is not told when a prior act is being used, or prior conviction, rather, is being used for conviction, for impeachment, rather. They're not told about the underlying facts of the case, correct?
That's correct, Your Honor. It would just be in the form of the Assistant District Attorney asking, are you the person who was convicted of this
Of armed
offense?
robbery, and that would be
That's
it.
correct. That's correct. And I think that lends itself to the fact, to essentially rebutting the defendant's argument that these crimes were substantially similar because there was a knife involved. And I think the record makes very clear that the judge engaged in the requiring balancing test here and properly found both that these offenses were not substantially similar and that the armed robbery goes to truthfulness.
Thank you. And seeing no further questions, the case has been well argued. We'll take it under advisement, and the case is submitted. Thank you, counsel.
Thank you, Your Honors.
Thank you.
Calling our third case, Commonwealth v. Jason, docket 23P1057.
Good morning.
One moment, please. And Attorney McKenna, good morning.
Thank you very much, Your Honor. Good morning. May it please the Court. James McKenna for Mr. Jason. I'd like to get right to the heart of the problem with the Superior Court decision. Essentially, the Court relied upon findings that were not supported by the record. And if I could refer the Court to the bottom of page 18 in the impounded appendix for a couple sentences that go on to page 19. And if I could just read quickly from them. This is the prosecutor in the transcript at the time of the conviction, of the plea. She describing the relationship between Mr. Jason and the victim. She reported that she met Mr. Jason when she moved into that neighborhood, that he lived down the street from her, that she had met him when she was about 11 years old, that around the time that she was 13 years old, she was breaking up with an age-appropriate boyfriend. She and Mr. Jason began to exchange some messages, and he wished to go back in time, and it goes on from there. From that, the Court writes, and I'm referring to page 64 in the record appendix in the decision. He makes reference to the defendant I'll read it. The defendant targeted and groomed a 11-year-old female and eventually entered into 2 years of sexual relations with numerous offense contexts. There's a reference to the Commonwealth's argument preceding that, but that's not supported by the record. He meets her when she's 11, based upon what the prosecutor recent to the record during the plea. He starts texting her when she's 13, and the judge finds that he targeted and groomed an 11-year-old female. That's just not supported.
So say he targeted her when she was 13. Does that make it
There's no
materially better? Is that
It does, Your Honor.
Okay.
In that there's no grooming. The relationship begins when she's 13. If the text messages represent the beginning of the relationship, there's no 2 years of grooming, as indicated by the Court. And that goes to the second, or actually the more consequential, unsupported finding of fact by the Superior Court. And all this relates to the idea that Roderick sets a standard. And what brings this case beyond that standard, according to the Superior Court, were these findings of fact. And they're not supported. The second one concerns the finding on page 65 of the record appendix by the court of the repetitive and compulsive offense context with a child, and there's also reference to obsessive behavior of stalking the victim.
Counsel, can I ask you a slightly different question, and certainly mindful of what the SJC said in Norman as far as consent to a GPS as a pretrial condition of release, but essentially that, I mean, it's not really consent when your choice is take the GPS or go to jail.
Yeah.
Okay. How does that play out, though, in terms of the difference between Roderick, where the defendant was found guilty by a jury and sentenced, so it was imposed, in this case, where it was a plea in which he agreed and accepted a GPS as part of a disposition that was negotiated in some way?
In that, in both cases, both there and here, the imposition was done without a balancing. And with the
No, but do we need to get there if the defendant agreed to it? I mean, the defendant can agree to anything pretty much within reason. He'd like to be placed on probation, right? Well, that's not exactly true. But in this case, there was certainly enough of a relationship between the condition and the crime and the facts that it would pass muster there. And if the defendant, again, agrees to something and consents to have a GPS, but then later says, no, I don't want it anymore, isn't that different than the court imposing that just as a result of a conviction?
It is different. And what makes it not decisive here is that the agreement's made at the time before Felice, when everyone in the room thought it's going to be imposed under Section 47. Before they knew that there had to be a balancing, counsel for both the prosecution and Mr. Jason and the judge, everyone thought this was going to happen. So there wasn't a question of, well, we should do a balancing of the factors at that point. But Your Honor, you make an outstanding point relative to the agreement, but it's not decisive here because of that everyone thought it had to be imposed. Here, with respect to compulsion and obsessive behavior, there's the felonious series of rapes over the course of 2 years. There's no indication that there's any compulsive behavior. Felice makes reference on page 705, and we quote this on page 14 of our brief, to there being no diagnosis of compulsive behavior on the part of Mr. Felice. There's no diagnosis here at all. There is a reference on page 35 of the impounded appendix, and it's in the reply brief and several other places, to the victim saying this at sentencing of Mr. Jason. You created a whole new Facebook with a strange name to see what I was doing since I blocked you on all social media. That's not enough to say it's obsessive. That's juvenile. And that was in 2014, before the stay-away orders in this case came out.
Why wouldn't that speak to grooming?
This was at the end of the relationship, at the end of when she's basically saying no more, and he's...
So if not grooming, why not to obsessiveness or obsession on some level? If she's shut him out on social media and then he creates essentially a fake person so that he can follow what she's doing, isn't that different than? And I'm trying to kind of just in my head
it's not
reconcile this case with Roderick. So can you? And I have one other question of that, but if you can address that one first.
This was in the same time frame as the rapes, the series of 50 rapes of the 13-year-olds, which...
So let me pick up on that. Roderick was essentially a couple people, one incident, situational opportunity, obviously horrible. The court said in Roderick, I mean, we already consider rape as an extraordinarily terrible offense, et cetera, et cetera. But why does the fact that the difference here, which is over 50 rapes during a 2-year period, is just different than one incident on one night in terms of the type of deterrence or investigative needs that might attach to it?
Thank you, Your Honor. That goes directly to what Roderick talked about in terms of deterrence, and your point relative to deterrence is it does suggest that there would be a different way to look at it than Roderick in that respect. They're both rapes. Rape is of multiple rapes of a sleeping woman in Roderick versus this. But Roderick talks about how, if I can quote, I think it's page 679 in Roderick. We recognize that the government has a valid interest in deterrence and investigation where the Commonwealth provides sufficient evidence that a defendant poses a demonstrable risk of reoffending. This Facebook foolishness was in 2014. At some point, and there's a district court proceeding followed by a Superior Court stay away order, and then 2 years later, there's a guilty plea. There's no indication, there's no GPS, according to the Superior Court docket. The 2 years between the stay away order and the guilty plea, there's no GPS. And there's no indication of any effort to contact the victim before the plea. After the plea, he's in prison for years, given deservedly in prison for years, and for the sort of behavior that included creating the Facebook page. That whole felonious activity was what he went to jail for, prison for years. During that time, there's no contact. Then he gets out, and as of the time of the hearing, he's out for 2.5 years, and there's no contact. He's a model prisoner. He's twice allowed to leave the state by the court, once to Florida, once to Connecticut. And this goes to what Roderick spoke about relative to your question about deterrence. The defendant poses a demonstrable risk of reoffending. That's just not here. This is someone who has had no contact since 2014 with the victim. This is also a case where you can see where the judge would find compulsive behavior, obsessive behavior, and grooming, even though they're not supported by the record, because the victim asked for that this continue. That the victim, according to the statement admitted into evidence by the victim, and
Well, I think that was probably offered by the Commonwealth. I don't want to speak for them. But because in Roderick, the SJC noted that the victim had not been spoken to, could not be located, so that was a factor the court weighed.
exactly.
So my assumption is that the Commonwealth did speak to the victim and wanted the victim to believe the shortcoming in Roderick, should she so choose.
You're absolutely right, Your Honor. And there's a statement by the victim which indicates considerable ongoing harm in our record appendix, in the impounded appendix. I think it's the impounded appendix.
I actually have a different question before you run out of time. You frame your argument as, in denying the defendant's motion, the court abused its discretion. And reading Roderick, we are told that the standard of review on this issue is de novo, not abuse of discretion.
Yes, Your Honor.
Okay. So
Yes.
which is it?
It's de novo, but it's abuse of discretion relative to relying upon unsupported findings. The reliance upon...
That wouldn't be, the findings are reviewed, as Roderick tells us, to determine whether or not they are clearly erroneous, not abuse of discretion.
Yes, Your Honor, that's correct.
So am I correct that a discretion there is no such thing as abuse of discretion in the context of this constitutional issue? We look at the facts to see if they're supported by the record or whether they are clearly erroneous or not, and then we look at the issue of law de novo. Is that correct?
Yes, Your Honor. And we quote that part of Roderick in our reply brief,
Yep.
just to make that point, because the law does have, as Roderick points out...
Yeah. What does de novo mean in this context? I have a little difficulty with that.
It means that before the court is a situation where there's a model prisoner, a model probationer, and all these other factors, this constellation of factors, and you don't have to rely upon what the judge said before. You don't have to rely upon the unsupported finding of compulsive behavior or obsessive behavior. You don't have to rely upon the contentions relative to grooming, which are unsupported. So as you weigh back and forth, it's your scale, not not deferring to what other judges have found.
Well, wait a minute a second. In Roderick, the issue was raised when the defendant moved to vacate the monitoring condition a few weeks before he was expected to be released from prison,
Yes, sir.
correct? Here, it's a very different factual predicate. He's been on probation for 2.5 years, and then he moves to vacate a condition that he apparently previously agreed to. In that circumstance, you're not just making this objective legal determination about whether or not the intrusion is warranted under the Constitution, but whether or not circumstances that have developed in the past 2.5 years justify the motion to vacate, right? So I guess I wonder, is this really a de novo kind of inquiry, or is it something that we have to defer to the judge's assessment of what's been happening, not only with the offense, but also in the intervening 2.5 years before this motion was filed?
Your Honor, thank you, Your Honor. And that does go directly to a positive distinction relative to Mr. Jason compared to Roderick. Mr. Roderick is still in prison. Mr. Jason's been out and evidencing no demonstrable risk of reoffending for 2.5 years. He's got a stronger case than Roderick did that way. And also in Roderick, they had the meaningless, as the court would suggest, exclusion zones. There are no exclusion zones here. And so the encyclopedic data being taken relative to Mr. Jason has no purpose. There's no risk of reoffense. The intrusion upon his Fourth Amendment rights is ongoing.
Well, it has a deterrent effect, we would agree, a deterrent effect to
It has a
prevent
deterrent effect,
future conduct, right?
which would be applicable if there was demonstrable risk of reoffense under Roderick on page 679. But there is none. He's had no contact in nearly a decade with the victim, during when he had no GPS and when he was in prison and now when he's been out. So from that perspective, he's got a stronger case than Roderick. I hope that answers your question, Your Honor.
Okay, seeing no further questions, we appreciate the argument. Thank you. We
Thank you,
will
Your
now
Honor.
hear from the Commonwealth.
Good morning. May it please the court, Rosella L. Corey for the Commonwealth. Where the Commonwealth conducts a warrantless search, as we are all aware, Article 14 is violated only where such a search is unreasonable. And to date, it has become axiomatic that not all searches require a warrant and probable cause to be reasonable and therefore constitutional. And that is from Feliz, 418 Mass, 689, pages 699 to 700, a 2019 case that was released before this defendant was released from his incarceration. In the context of GPS monitoring as a condition of probation, the judge is required to consider a constellation of factors, which includes the intrusiveness of the search and a defendant's particular circumstances, including past convictions, probation violations, and risk of recidivism, and also the purpose for which monitoring was imposed. Here, I would suggest that this court would do well to follow the logic of the motion judge who did engage in an appropriate review of this defendant's individual circumstances. He did consider the nature of this defendant's crimes. There were multiple contact offenses with a minor. This defendant pleaded guilty to 5 counts of rape of a child that occurred over a 2-year period. The victim herself gave information indicating that there were over 50 instances of having sex with a child.
So let me stop you right there. My first question is, do you agree with your brother that the standard of review here is de novo?
Yes, normally it is abuse of discretion, but where there is a constitutional issue, it is de novo.
So under our de novo review, it seems to me that your challenge is to distinguish this case from Roderick. You seem to be doing so, bless you, sir. You seem to be doing so by noting that in this case, there were 5 convictions for rape of a child and over 50 instances of rape of a child, whereas in Roderick, there was 1 instance of rape involving an adult who I think was homeless in Connecticut and came to the defendant's home where the rape occurred.
Yes.
Why does that matter?
It matters because no one factor is dispositive of the totality of the circumstances. It matters because this defendant has engaged in conduct that has not been contemplated by a reviewing court in the context of whether or not the GPS condition is appropriate. Even looking at Feliz, which did involve child pornography, those were non-contact offenses. And even in the SJC's second contemplation of Feliz, they did uphold the condition of probation that allowed probation to search that defendant's electronic devices pretty much at any time, so long as there was no search for location information. And I would argue, honestly, in this case where there is a victim who, as the Commonwealth pointed out at the hearing, does remain presumably local to a degree, and who has explicitly asked not to have exclusion zones imposed on this defendant because the victim would prefer that their address not even be made available in any way
I want to go back to my question, though. Everything you're saying, I understand, it's in the case law. But Feliz says in conducting, rather it's the Johnson case that says, in conducting the balancing test you reference, a judge, quote, may consider a constellation of factors, including, among others, the intrusiveness of the search, defendant's particular circumstances, such as his or her criminal convictions, past probation violations, risk of recidivism, and probationary purposes, if any, for which the monitoring was imposed. I don't see anywhere in those constellation of factors a distinction between someone who committed an offense multiple times against one victim and someone who offended once against a victim. Why is there a material distinction for purposes of this particular analysis?
I would say that it does fall within the category of the nature of the offense, and I would also say that it is not something that, frankly, can be put in a vacuum and set aside during this consideration of whether or not GPS monitoring is appropriate for this defendant. There are other special conditions of this defendant's probation, all of which are intended to keep this particular defendant from having contact with children. None of those conditions have been challenged, and it is only this GPS element, which, admittedly there are no exclusion zones in this case, but there are, I think the investigative and deterrent purpose is heightened in this case. This is a case where the Commonwealth is concerned about keeping an individual away from children, and the SJC has quoted with approval the United States Supreme Court case that indicates that the protection of children from sexual exploitation is one of the highest priorities a government can take.
Is your argument that because it was the crime involving a child, that it just categorically it deserves a different analysis than Roderick? I mean, I think Mr. McKenna made a good point about the finding of the defendant having active compulsively may not be supported. So is it just sort of based on the nature of the crime itself that you think deserves a different analysis?
I would say that Roderick does deal with what one could argue is sort of an isolated incident. I would say that here there are repeated offenses, and the fact that these repeated offenses involve a child heighten the concern that the Commonwealth has about knowing.
So it's the sustained and repetitive nature of these crimes.
Yes.
But not necessarily a fact that involved a child and there's some kind of compulsion that's inherent in that
I do think that the element that this did involve a child has to be something that is also considered and does heighten the case. But I do also look at Feliz, where again, it was child pornography charges. They were non-contact offenses. And the SJC found that an interest in that defendant's location was not necessarily something that the government could establish based on the nature of those offenses. Here, it is a child, so we're already more concerned than we tend to be with straightforward sexual assault. And as Your Honor pointed out, it is a prolonged period of contact. It is, frankly, I do believe that, while the record may not be strong in indicating grooming behavior, I think there has to be an inference that this defendant did engage in grooming. And the Commonwealth does quote the definition of grooming from Commonwealth versus McDonough on page 16 of my brief. And essentially, Oh,
No,
I'm
go ahead.
sorry.
Finish your, I'll wait till you finish.
Which essentially is deliberate actions taken by a defendant to expose a child to sexual material with the ultimate goal of the formulation of an emotional connection with that child and a reduction of the child's inhibitions to prepare that child for sexual activity.
What's
And,
the evidence of grooming in the record?
So it's stated that they met when she was 11. It stated that she was going through a breakup with an age-appropriate boyfriend around the time she was 13. I would posit to this court that it is a fair inference that their first contact when she turned 13 was not that initial sexual encounter. There was a lead up to that. There were
What's the
steps.
evidence of that in the record?
I would say it's an inference. I believe that there is something on, I believe it's page 18 of the impounded appendix where the Commonwealth does state that they began exchanging messages when she was around 13, and then in November of that year, they had their first, there was the first sexual encounter.
So when we analyze this in terms of the material distinction between this case and Roderick, and it being I understand your argument that the victim here was a child and that there were far more incidents here, right?
Yes.
Does that go into the likelihood that the defendant will recidivate box? Does that go, what is that informing us of? Does that mean that he needs more deterrence? What's the conclusion that we draw from that, and how do we draw that conclusion? Based on what facts or factors?
I would argue that it probably does have an element of deterrence, even without a finding of a psychological condition. The evidence does support that there is something going on here that resulted in an adult man continuously raping a child for 2 years. There is an element there that indicates that this is a person who had plenty of opportunities to end this encounter and chose not to. So that I would say that it does, to a degree, speak to recidivism.
I mean, it's hard, the plea facts are pretty sparse.
Yes.
Understandably, and for very good reason, I get. But can you speak to a little bit about what, the issue of the plea in this case as opposed to the verdict and imposition of sentence? Do you see that makes any difference whatsoever, or you think not really?
I do think it probably carries some weight. This is a defendant who was charged with 6 counts of rape of a child and ended up pleading to 5 of them, which is not the most favorable disposition a person can obtain.
I guess I'm asking in the context of him consenting to the GPS as opposed to it being imposed upon him relative to his privacy rights and constitutional, otherwise his constitutional rights.
Right, and during the plea colloquy, the judge did ask, say you are aware that you will be placed on GPS monitoring, does that change your willingness to accept this plea? The defendant indicated that it did not. The judge also asked about the costs associated with GPS, and the defendant indicated that even that was not a deterrent. So there is that element, but the Commonwealth does not dispute that at the time the defendant was sentenced, this was a crime where GPS would have been.
Do we need to weigh the length of the probation, because this defendant's length of probation was longer than Roderick when we talk about the degree to which his privacy interests are being encroached upon?
I think it could be a factor for this court to consider, but I do also think another factor for this court to consider is that this defendant was released after Felice was released by the SJC, and this defendant also waited about halfway through his probationary period before bringing this challenge. He was not concerned about the intrusion on his privacy during, the early days of his probation, even though, he was aware that that was a challenge that could be brought and had been brought successfully.
Seeing no further questions,
I will rest on my filings. Thank you very much.
thank you very much. Thank you, counsel, for the excellent arguments. Case is submitted. Next case, docket 22P1085 in the matter of JL. Before you begin, counsel, I'll remind you that this case is impounded, so please refrain from using any names of the parties involved or any other impounded material.
Good morning. May it please the court. I'm Lois Farmer. I represent JL. This case comes to you with a couple of twists that are a little bit unusual. This is a civil commitment case under General Laws, Chapter 123, Section 35. That's alcohol abuse disorder. The first twist is that my client is now deceased. I had submitted a suggestion of death on the record, and the single justice suggested or requested that I submit a memorandum to you as to whether or not this should go forward for appellate review. And then when I did that, they scheduled the hearing. In that, I relied on In re Santos in my memorandum. In re Santos was a case of an individual who was a sexually dangerous person petitioning for discharge. And that particular person died before the oral argument, but all parties had briefed it. And in re Santos, the SJC took the case and said basically you would take the case, it would still be available for appellate review if the issues are capable of repetition yet evading review. The case presents substantial issues of due process or resolution of the case would be in the public interest. I would suggest that this commitment case pretty well touches upon all three.
Let me touch on that. The case is very well briefed. It's an interesting issue. Would you agree that this is a matter for this court's discretion whether or not to address it?
Yes, I would. I would say it's discretion, but I think that you should nevertheless, at least well, there's another twist to this, but at least with regard to these issues, I think it would be important for you to address many of these issues. So the next twist, if I can get to it, is that in this case, I did challenge the scope of the expert testimony and whether or not it even qualified as expert testimony. As we speak here, there are two cases pending being argued in the SJC that addresses the constitutionality of the expert provision of Section 35.
It's scheduled for argument today, and its dockets 13492 and 13493.
Exactly, you're ahead of me. So in that case, essentially what they do is they challenge the constitutionality of expert testimony because there's a lack of standard in Section 35 as to what that expert testimony is supposed to be. I would suggest that what this court should do with regard to this issue, if you decide that the expert testimony in my case is something that needs to be decided, I would suggest you need to wait until the SJC rules on its case. This is what the appellate court did last year in one of my cases. I had a care and protection case that I argued based on whether or not an expert met the qualifications required under ICWA, Indian Child Welfare Act. That's in the matter of Leonard. And the Supreme Court, of the United States was hearing a full-on challenge to ICWA, the whole thing. And so the appellate court said, what do we do? And so it decided to stay the decision on the case pending the decision in the Supreme Court, and then I had to submit a status report to the court, and they ultimately rendered their decision and agreed with me that that expert was not qualified, highly intelligent, but not qualified under ICWA. So I'd suggest—
I'm sorry to interrupt you, but let me ask you another question before we get to the merits of the argument.
Sure.
At the end of your excellent brief, you ask us to remand and for dismissal of the petition. Are you changing your request for relief in light of your client's status?
I would. I would say that it should be vacated and dismissed, the order of civil commitment at this point. If you decide that the commitment itself was not properly based on the law.
Okay if I get into a substantive question as long as we're here?
Your commission's just as good as mine.
There you go, that's all right. So let me ask, my first, I'm trying to take it logically because as I read this, it just raised so many issues. Your position is that the judge's finding that hearsay is substantially reliable must be express.
Yes, and
Not necessarily in writing, but it needs to be expressed. Is that
well,
fair?
the cases say that the judge has to find in writing, I believe it says in writing, that he relied on hearsay and that it had sufficient indicia of reliability. However, if I can,
Sure.
another twist, the judge did not indicate that there was any hearsay in his order. There is a specific point in the form. There's an order and findings.
No, she didn't fill it out.
It wasn't filled out.
Right, but in her, so let me ask it, let me throw it this way. So your client's attorney during the hearing raised hearsay only in one line at the end of his summation. The judge said, well, what are you talking about? And he said, well, the evidence essentially of crack use. And the judge said, yeah, well, your client, when asked by his father, acknowledged it, so what about that? And then they moved on. So a couple issues, it seems to me there. Number one, if there's no objection to it and there's no argument other than a cursory argument at the end, how does that impact whether the judge could consider it? Does the judge still have to make a finding of substantial reliability? And then what do you do with the cases, I mean, the old case is Nunez, and then there are a number of 128s and Rule 23s that essentially say it hasn't been answered, that say that the judge implicitly found that the hearsay was substantially reliable because the judge used that evidence in the judge's determination, which is what happened here. And the judge clearly used a combination of direct evidence from the father and hearsay from the father in her findings, both oral and written. Fair?
The judge seemed to, but actually, as I was going back and reading over it, the judge really was relying just on the father's evidence of what the father observed. The judge really didn't make any findings with regard to hearsay or address it pertaining to the less restrictive pertaining to the likelihood of serious harm aspect. Father testified about his concern about his son who has been drinking for years, using marijuana, then he believes taking crack, although the appellate division found that the evidence was not sufficient for that finding. And then also that the father was concerned that he was having to go and place his son into hotel rooms because he was losing his apartment, because he was raising holy sin.
But the judge made findings which could only have been based on hearsay that from the father, that of homelessness, that's maybe not so much, but frequent robberies, weekly beatings, resulting in black eyes. Now, you could certainly testify to the black eyes that he saw.
At the court, but we don't know where it came
But in terms of how those
from.
occurred, that's all based on hearsay, and then there was one woman. So, again, to the extent that the judge made, and she did make findings on that, she certainly orally, why are those not at least implicitly an indication that she found the information substantially reliable, and then it's incumbent upon us to look at the record and say, okay, was there evidence of substantial reliability here?
If she did implicitly find it, I would say that that was an error. Because if you look at the evidence, it was fine under the finding of the alcohol abuse disorder. I'm not going to challenge that the son came home, raised holy sin, and was, a bad actor, but never assaultive with his father that the father ever testified to. So I think that with regard to that aspect of it, we're not challenging the disorder. What we're challenging is the likelihood of serious harm and the evidence to support it, and that evidence was third to fourth level hearsay.
What was it, though? I mean, the father witnesses the son being kicked out of hotels. He sees this, maybe he's not watching the beatings, but he's seeing his son show up being beaten every week. He knows that the son comes to get his disability money from the father. He's raising heck that he's intoxicated. It seems like there is some direct evidence that the father was testifying to, and of course the judge found his testimony very credible in the hearing. So I agree. The psychologist's testimony seems mainly hearsay, but it does seem like the father was providing really direct evidence of of really the suffering that his son was going through.
I honestly feel that, and I submit that the father's testimony, I disagree that it was that sufficiently reliable. When you're talking about the hearsay issue, there has to be, based on personal knowledge and direct observation. Yes, the father was aware that the son was being evicted, not kicked out, not physically kicked out, but evicted from his various housings that the father set up for him. Father would even go and clean the place up. The son was slovenly, but
Why isn't that direct knowledge? If the father's setting up at a hotel and he's getting kicked out, that seems like direct.
that goes to the disorder. But it still doesn't show really the likelihood of serious harm. And let's remember, the father testified, this has been going on for years. The testimony that it was happening, getting beaten up weekly. Well, friends, somebody in the community told this woman who told the father that he was being beaten up weekly, but father didn't actually see it all the time. He did not see anything, he didn't testify to anything more than one black eye, other than the one that
Didn't
he
he
was
testify to
sporting.
observing his son's injuries, though? Not just the
He
black
didn't
eye?
testify really to the injuries, and you'd think that, the son had supposedly gone to the hospital. He didn't go to the hospital to pick his son up to get out of it. He didn't testify to anything that had the corroboration or under circumstances that supports veracity of the people saying that this young man was getting beaten up. Yes, they said beaten up every week, but that can be an elaboration based on the long period of time during which this son was suffering from the disorder. So, but the son wasn't at home that much for the father to see it. He came in 10 times maybe in the previous year, and he didn't say that I saw a black eye every week. And the question again is that enough?
He certainly could see his son was in this severe state of vulnerability, right? He was unhoused. He was suffering some kinds of injuries from, he was going through alcohol use disorder. I mean, I guess I wonder, like, how much of omniscience do you expect a petitioner in this kind of circumstance to have? Because we don't follow people, our loved ones around, but certainly I could see a father sort of saying, from what I could see, there was certainly a lot of evidence that his son was in a very, very vulnerable state and very, vulnerable to abuse by other people.
I can agree with you that the father had really deep concern about his son. That I can tell you, and I'm the one that spoke to him when he called about his son having died. There was a deep concern there, and whether that caused an embellishment perhaps of what he saw, because if you really read his testimony, he focuses not so much on harm, he focuses on the alcohol, he focuses on the crack, which the appellate division said there's not enough information on. He raises the concern that his son is going to go to heroin next. It's the substance abuse that was key to his concerns. And then he did say that he didn't sleep because he was afraid that his son would be killed.
Can I shift gears on you a moment? So as far as the least restrictive alternative, what's your position on whose burden it is in a 35? Now, on a 15 competency, the ASJC has just said it's on the Commonwealth, right? They have to at least present some evidence that's not that this is the least restrictive alternative. In the situation of a 7 and 8, you had a hospital there, right? So it's the hospital's burden at least to present that they've made some inquiry and there's no less restrictive alternative. Are we expecting that fathers, mothers, brothers, other family members, whomever it may be, it's incumbent upon them to present less restrictive alternatives, or is it then become the role of the court on its own to do that? Or in this case, does the judge say, well, the respondent wasn't cooperative, wouldn't talk to the psychologist, I don't have any other information, no one's proposed a less restrictive alternative, and what I'm looking at here is someone who's in a wheelchair, looks like he's about to have withdrawal, and let's get him out of here as fast as we can, and what's the nearest place where he's going to go? And by the way, we sent someone into Boston, or, you know, last year, and the person died on the ride, so we're not doing that.
Your time has expired, but of course, you can answer the question, of course.
Thank you. That is a conundrum, I will admit. I do think that the burden is on the petitioner. I think the problem with this process is the petitioner is not afforded help, victim witness person or something, to help the person come in and know what to say and what have you, but is still nevertheless, the burden is on the petitioner, in this case, the father. In other cases, it may be a professional, but here it is. But it would be nice, I think, be helpful if there was something set up to assist the parent in understanding, you might need a little more information, who have you got, you know, whatever. Father, and I will concede to you, father did say he tried to get the son into some sort of hospitalization, and the father begged the court to do that for him.
Any further questions? No, thank you. Anything further?
Thank you. Thank you.
No, excellent, thank you. Well argued, the case is under advisement and has been submitted. Thank you. Keep going?
Yeah.
We will call our next case. I believe it's docket 23P742, KRAMER versus KRAMER. Always wanted to preside over this case. One moment, please. Okay, we will hear first from counsel for the appellant, Attorney Dombrowski.
Good morning, members of the panel. May it please the court, my name is Edward Dombrowski, and I represent the appellant, Mr. Daniel KRAMER. The matter that is before this court today relates to an amended complaint for contempt judgment that issued in February of 2023. The underlying issue that we are faced with is how tax returns are defined. And specifically, in this case, the parties, which is their right, worked out an agreement vis-a-vis a separation agreement where they defined all terms, one of which, and what is before you today, is the term related to disclosure of income vis-a-vis tax returns. And their agreement says in no uncertain terms that there are really two components to that disclosure. The first is, beginning in tax year 2016, the parties are to exchange tax returns on an annual basis. That is subsection 1.
I'm not sure I agree with that. I mean, there are two parts of this case, right? One is the order of the discovery master that was approved by the judge, which we'll get to later. But the first is, what does the agreement state?
Correct.
And I'm at Record Appendix 62 and 63. It actually starts with, under financial disclosures, it says, on or before March 1st of each year, commencing in 2016, each party shall deliver to the other a copy of W-2s, K-1s, 1099s, husband's total compensation statement, etc. It then goes down and there's an and, which is underlined, and the and goes on and it has two subparts, subpart 1, and then on RA 63, subpart 2. Can't that be read, because of that and, it's in the conjunctive, that each party must deliver the W-2s, K-1s, 1099s, et cetera, every year, and then comply with either sub 1 or sub 2? Why is that not a correct reading of the agreement?
I would agree that it is.
Okay.
And when you take the first section that...
Did the husband deliver to the wife a copy of the W-2, K-1, 1099s total compensation statement, incentive award, incentive plan summary, and deferred award summary, or their successors?
He did. That's not in dispute.
That is not in dispute?
That is not in dispute, no. What is in dispute is subsection 1 or subsection 2. And specifically, subsection 1 lays out that it would be a traditional exchange of tax returns, as is commonplace in these agreements. However, there is what I'll call a sleeper provision that is only awoken when a party remarries, and that is subsection 2, or being the operative word there. And when subsection 2 kicks in upon a party's remarriage, that changes things. And it's quite apparent, a plain reading of this indicates that, all right, well, if you have a party that remarries, then presumably they'll file a joint tax return, in which case that new spouse's financial information, and not just financial information, but it could also mean things like medical information and the like. There are different disclosures that are made on tax returns, obviously, relative to parties. That becomes an issue. And so the parties anticipated that with this agreed upon, bargained for provision that is reciprocal. It applies to either party upon remarriage. In this case, it was only Mr. KRAMER who ended up having been remarried as of the time of this issue coming up. But ultimately, this is clearly intended to protect the privacy rights of a non-party upon a party's remarriage.
So the discovery master essentially changed that unilaterally on some level. Fair?
I think it's hard to say what the discovery master did, because the discovery master entered 2 orders. One is the order that he entered back, he filed back on the July 21st of 2022, which makes reference to tax returns. But then he issued a subsequent order that I submitted to this court that actually issued 2 days after my brief was due. That he filed that on September 7th of 2023, in which paragraph 2 of that specifically mirrors the language that is in this agreement.
Right, but we're focused on the temporary order that's at issue that your client was found in contempt of, right? So the subsequent order, I think the focus is, did the judge properly find your client to be in contempt of the temporary order? You haven't challenged the temporary order. You haven't appealed that. Your only appeal is from the contempt finding. So what's your argument as to that?
The definition of tax returns was as the parties had agreed in their agreement. In
the separation agreement.
In their separation from 2015.
Right, but we're talking about the temporary order that incorporated the discovery master's order on discovery, and that refers to tax returns. So you can't fall back on the separation agreement that is a different provision. We have to focus on the order that's an issue that your client was found in contempt of. My client acted in good faith based upon his interpretation of what the tax returns meant, because back as early as 2015, the parties had identified tax returns as such and had operated functioning in that way.
How is the term complete tax returns from 2018 to 2021 ambiguous? And I understand the argument that, look, under the original agreement, we complied with what we were required to do. Now the discovery master comes in and says, no, you give complete tax returns from 2018 to 2021. The judge adopts the discovery master's order as a judicial order from the court. There's ways to fight that. You can seek to move for a stay, you can seek reconsideration. There's all sorts of mechanisms available. But I'm not sure a correct mechanism available is just to reinterpret what the discovery master and the judge ordered you to provide. Again, complete tax returns from 2018 to 2021. How is that ambiguous?
When it became an issue before, as a part of the complaint for contempt, and once it became clear that the court was interpreting that not as the parties had defined tax returns, but instead taking a plain reading as if that provision did not exist within the separation agreement, my client did file a motion to reconsider or otherwise modify, and that was then denied by the court. Now the timing is somewhat unique in that that followed the court's interpretation, I should say, follow the trial court's interpretation on two instances. On January 27th of 2023, the court issued its original complaint for contempt judgment. That contempt judgment actually cited subsection 1, which was inapplicable because of my client's remarriage.
Right,
So
right,
the-
and the court then amended that and got rid of that
Well,
section.
the court then stripped away its only basis.
No, the basis was the language of the temporary order, right? I mean, so this whole argument that, well, you didn't quite understand what the temporary order meant. The temporary order issued on July 25th, 2022. There was a status conference on August 1st, 2022. And you said in that, well, we think there was an oversight on Judge DeGangi's part because we spent hours talking about these tax returns. You said that conflicts with the agreement. You talked about filing a motion with the discovery master to address this issue, which you never did. So you knew a week afterwards, after the temporary order was issued, that this covered tax returns, and yet your client didn't comply with that.
Respectfully, I don't believe I indicated filing a motion. I believe I indicated raising it either with the trial judge or with the discovery master, which I subsequently did. And the second order that you have from the discovery master, the September 7th order, is reflective of the fact that he's using these terms indiscriminately. He's saying complete tax returns, he's saying tax returns, then he's adopting the language specifically that is in the parties' agreement.
That language is clear as day. I mean, you can say, well, maybe, I don't know how we even process the document you filed today, but with the issue, the only issue before us now was the temporary order issued on July 25th, 2022 clear as to your client's obligation to produce tax returns, and it clearly was. And you knew it at the time.
Respectfully, the issue is not only what the discovery master's order said, but it's also the issue of the ability of a trial judge to modify an essential element bargained for provision within an agreement without there being a complaint for modification seeking such relief, without there being any basis.
Right, but there, as Justice Neyman said earlier, there are avenues of relief that are available besides, well, I'm just not going to comply with it, right? I mean, there are other avenues. If you didn't like the judge's order, there are lots of ways you can attack it.
Well, it wasn't a matter of not liking the judge's order. It was a matter of how the order would be interpreted. And it was interpreted in the context of how the parties had defined tax returns based on their 2015 agreements.
But you didn't move to reconsider or otherwise modify the temporary order until March 30th, 2023, after the judge entered the amended judgment for contempt in February 23rd.
Because in February of 2023, we had raised this issue with the judge relative to, it appears that Your Honor has interpreted tax returns in a way that's in contravention to what the agreement calls for. And then when the judge on February 23rd, 2023, then issued her amended judgment, which then just stripped out any reference to the agreement, then yes, at that point we did file, because then it became clear to us. I should also point out that Judge Texera had been the judge on August 1st. Judge Sauer became the judge soon thereafter. I believe the last time Judge Texera was on the case would have been August 1st. Then there was a transition of judges. So we had a series of hearings before Judge Sauer, and so I was relying upon those representations relative to her on that.
And then when you moved to reconsider, the judge said no.
Judge Texera.
Yes, right, and said, no, the husband was less than forthcoming with his financial information, and result, the temporary order was needed to make clear that you need to produce the tax returns, right? And you haven't appealed from the denial of your motion for reconsideration. You haven't appealed from the temporary order itself. The only issue before us is the contempt finding.
Well, an appeal from the motion we had filed that was acted upon by Judge Texera would have been an interlocutory appeal, because that would have only been an order of the court. We had already, because of the timing of this, had already had this appeal pending. And I should also point out that in practical terms here, what we're talking about is the intention of the parties, and clearly the intention of the discovery master, presumably, is to make sure that this information is conveyed, right? My client's income information is conveyed appropriately. So this notion that somehow by producing tax returns themselves, as compared with all of the information and a certified letter by the CPA who prepares the tax returns is truly a distinction without a difference. But the bigger concern that I have relative to that...
Well, it's not a distinction without a difference, because the judge specifically found that, he said at the August 1st, 2022 status conference, this case has smelled since I began sitting on it. People do not have, one thing that irks me to no end is when people do not have their information flow freely, because it tells me you're trying to hide something. That's what he said to you about your production of data regarding where your client's income was going. So there were real concerns about the information that you're producing, whether it was actually fully reflecting the income that was needed by the former wife to sort of assess the issue.
But there would be no additional information that would be gleaned from the tangible tax returns as compared with all the information, because all the supporting documentation is needing to be produced regardless. So there would be no additional information gleaned except for the incredible encroachment upon my client's new wife's privacy, and that was without any expectation of having that violation exist. When the parties signed this agreement back in 2015, it was with the express intent that a party and their spouse came into this agreement with the understanding that if they filed joint tax returns, that information, their private information, was protected. What this judge has tried to do, Judge Texera has tried to do, is in essence say, I'm going to go back and retroactively modify all the way back. And even complaints for modification can only go back to the date of service, because it's proper and appropriate for a party to be on notice. Had my client known that this was an issue, which, mind you, wife had never raised as an issue of wanting these, she never filed a complaint for modification, seeking any sort of amendments, never offered there are changed circumstances where these returns are now required. But now we're set with a situation whereby my client's wife, who's a non-resident, non-party, would be forced to have all of her financial information and her medical information released to the other party for years. Every year they filed that joint tax return, they felt as if they were protected by the provision that specifically offered that protection. And then to upend this because a judge has a hunch that a party is not being forthcoming is sufficient basis to then have a modification when there's not even a complaint for modification pending relative to this issue.
Your time has expired, but let me see if there's further questions. No? If you'd like to sum up, go ahead.
So I would just say that the balancing of interests here, if you're looking to get the information from one party to the other, the tax preparer who had the certified letter, which they've never raised objection to, and all of the information that flows from that, keeps the information contained to the party who is the party to the action, while protecting his wife, who otherwise lays bare and exposed through no fault of her own, and there's no way my client could have anticipated that sort of retroactive exposure, because that's not what the law provides for. It doesn't allow for that. You have to be on notice before you can have that kind of a modification. It would be incredibly damaging to this woman who has nothing to do with this litigation to have all of her life out there. Thank you.
Thank you very much. And Attorney Ronan?
Good morning, Justices. My name is John Ronan with Salvana Calabro next to me. We're representing Robin KRAMER, the plaintiff appellee. Before I begin my argument in chief, Your Honor, and Justices, I just must bring your attention the second order that has just been talked about by my brother that was submitted to me last night at 4:33 p.m. via a letter. There is no request for a supplemental brief at that point, Your Honor. There's no request as a 16L letter. Frankly, Your Honor, it's a 9-7 proposed order that was vacated by the trial court. That was not put into the letter, Your Honor. That was vacated at Attorney Dombrowski's request. We had a hearing on that prior to my brief being due. Thank you. Before you today, though, Your Honor, is this amended judgment of contempt. We must look to the standard of review. A finding of contempt in the Commonwealth against the defendant must meet a clear and convincing evidence of disobedience in a clear and unequivocal order under In re Burchell. The order is clear on its face, Your Honor, and to say so otherwise is disingenuous. Complete tax returns from 2018 to 2021 is what's ordered, including but not limited to.
The settlement agreement was incorporated into the judgment nisi?
It was, Your Honor.
Okay. Suppose we agree with you that I'm going to call it the Discovery Master's order, which was approved by the judge and effectuated by the judge. Let's just call it, for sake of argument, the Discovery Master order. So assume we agree that the Discovery Master order was clear and unequivocal, but further assume that it contravened another court order, the court judgment. There are concerns with that. What is to be done about that? What can be done about that?
Well, Your Honor, as I will get into, you could have Attorney Dombrowski could have filed a motion to alter and amend, as we were there at the status conference, and done so. It could have been brought up on the 231, Section 18, to a single justice appeal, Your Honor. We stood there on August 1st, Your Honor, and it was entered and docketed that day, as you can see from the docket. We discussed it at length, Your Honor, that day, and I put it into my supplemental volume, Your Honor, where it has become to the point, Your Honor, and this is why Judge DeGangi was actually, at this point, he was sua sponte appointed at this point because discovery was so bad. And I included, Your Honor, in my supplemental appendix, the financial statements, where Mr. KRAMER started to funnel in his new wife. He used her as a shell, right, to get around that. You see that all of his income went to her accounts. He wasn't privy to them, right? The privacy matters that was talked about by Attorney Dombrowski never pled in any of his briefs. Under Palmer v. Murphy, Your Honor, he can't even make that argument as we sit here today.
Well, let's assume, I'm sorry.
No, so all that was, you're saying, discussed and vetted in front of the Discovery Master instead of
Correct
Judge
hours, Your Honor. If you see that in
DeGangi,
the supplemental appendix,
Yep.
Attorney Dombrowski actually says we spent 2 days, one in April and one in June of 2022. What we don't have before the court, because it went to the Discovery
And
Master.
the whole
is-
issue of you saying, well, he's just using her as a shell, that's why we need the tax returns, that's why this whole privacy agreement doesn't really apply anymore. That's all part of the conversation in front of the judge and the master.
100%, Justice Brennan.
So
Well,
can I ask?
we're bound by the record that's
I understood,
before
Your
us,
Honor.
so
I understood.
Can I ask just conceptually, is your argument that the temporary order that incorporated the Discovery Master's order was a modification of the divorce judgment, or was it something else?
It's a temporary order within the modification as well as the contempts that we're on at this point, Your Honor.
Say that again, I'm sorry.
It's a temporary order that's entered on both the modifications, whether you call it a modification of the separation agreement or not, it's a new action. So I think at this point, Your Honor, it's an order of the court, and it's an order of the court in time.
I'm trying to get to Justice Neyman's question. How do we conceptualize there's the divorce judgment and there is the temporary discovery order?
Well,
is one the modification of the other? Are they two different things? I'm just trying to, how do we assess this?
I believe the court itself, Your Honor, can modify that based on Kavanaugh, because it is a merged provision within the court. They can do that. They run discovery under Rule 26.
But no one in this case has ever referenced this as a modification. I mean,
The order, Your Honor?
yes.
No, Your Honor, it was a temporary order entered by the Discovery Master at that point.
So you're saying it could be modified, but in terms of what's before us, it has not been modified.
It has not been, it was modified, Your Honor, by the trial court, by this temporary order. If we enter into a new judgment, it goes away, and then it would go back to the
The
separation
judge
agreement,
call it a
correct?
modification?
No, they entered it as a temporary order under a Discovery Master order.
Temporary orders, what you're saying is a de facto modification.
Yes, it's a discovery issue within the new action.
I have a slightly different question than that is, I want you to assume that there are legitimate privacy concerns in the wife's information, and I want you to further assume, as contemplated by the original settlement agreement, are there mechanisms that can be effectuated to continue to protect those while still sharing that information?
Yes, there are, one at the time, it could have survived that provision, so it could have never have been changed.
Now, how about now?
Now, we could have entered into, the Discovery Master could have redacted wife's information on the tax returns. The Discovery Master we could have entered into an NDA or a confidentiality agreement. They could have voluntarily redacted that.
Would a judge have power to, for example, review it in camera and make a determination as to what is necessary to effectuate the order and what can be segregated as private and irrelevant?
I believe under the mechanisms we have in this case, Your Honor, in the record, it would have actually gone to the discovery master to be reviewed in camera.
Well, the judge would have to order it now to go to the discovery. I'm thinking, for example, on remand, should the judge wish to do so.
Right. I think, Your Honor, it would go to the discovery master because all issues of discovery go to that, and then it would have to be an order from the trial court to the discovery master to look at that.
Okay.
So, Your Honor, as we say here, we had a clear and unequivocal order based on Birchall, and we have a clear and convincing, not to the point, Your Honor, it's a clear and convincing disobedience of that order. He didn't produce the tax returns. We're still standing here today without the tax returns. And
Did you oppose the, when the initial judgment of contempt was entered, and then the former husband moves to modify and says, no, you got this wrong because you referred to the separation agreement in that. Did you oppose that, or did you agree with that should be modified to excise that from the order?
I didn't oppose specifically that piece. What I opposed was, it wasn't just when he went to modify, he wanted to get rid of the entire judgment. So I would say it was a partial opposition, Your Honor. Does that make sense?
But as to the change that the judge made with the amended judgment, you don't
I
have
have
any
no
comment
issue
it?
with that, Your Honor.
Okay.
Do you have an example of a case like this one where a court has entered an order that in effect modifies an earlier, let's call it separation agreement or earlier agreement, without actually going through the modification motion and proceeding?
Well, Your Honor, I think under Feinstein, which is in my brief, it talks about within the contempt judgment, Your Honor, modifying as you go forward on this piece. So I think that Feinstein does cover this as we talk about it, and I don't have the site directly in front of me, Your Honor,
No,
but
it's
it is in my
95
brief.
Mass Ep. Court 230, I read it, yeah.
Thank you. So, and, under Huddleston, as well as Kavanaugh, Your Honor, I think they have the inherent power to do so at that point, particularly where we have the malfeasance and we have the unclean hands that have gone forward. And when I say unclean hands, Your Honor, he has put his own new wife in the middle of this divorce. But she's out of state, so I can't depose her. I can't get the information from her as the money gets flowed through her. And so what do we have to do at that point? And this is just on, if we look at the order as it is, it was the reason this was after 2 days with the discovery master, Your Honor. Multiple, as the discovery master references in his own order, there was cross emails, memos, and two full days with the discovery master, Your Honor, to do this. And this is the order that came out. It wasn't done lightly. It wasn't done at a snap of a finger. It wasn't that. It was entered. We had a status conference. It was entered, and then it was not followed. And that's what we are today, Your Honor. It's a contempt. And on that basis of a contempt, we have a clear and unequivocal order and a clear and unequivocal disobedience. That's it. It has to stop right there. It's not going back to look at this, whether the order itself, because that should have been either appealed at that time, Your Honor, or moved to alter and amend, or any of this. None of this, Your Honor, that there's a definition of tax returns or anything else that went into it. It says it straight out. Complete tax returns and schedules, right? The reason for this was the malfeasance that went on with Mr. KRAMER behind this. It's not taken lightly. It's not flipped out just as an order that we do this all the time, Your Honor. This was argued both at the status conference, both with the discovery master, and everything else in between, Your Honor.
Can I ask, what information do you expect if you do end up getting the tax returns? What information do you expect to be able to get from those returns that you don't have now that will explain kind of issues that are still in contention?
I believe there's more income out there, Your Honor.
Sorry?
I believe there's more income out there that has not been disclosed.
Okay.
And that income, and as I mentioned it, and you'll see it in the status conference that day, Axiom Capital is one of those, Your Honor, where he received a payment of $100,000 that I found through his bank statements and went through, never provided a 1099 for it. And it says it within the record here, Your Honor, is that it says that, oh, that was a gift from someone for stock.
So what about my
$100,000.
colleague's point that the 1099s are required to be produced under the first prong of the of the separation agreement.
Correct.
So have you not received all the 1099s?
I don't have one for Axiom Capital.
Okay. So you think that if you get the tax returns, then you'll be able to
I think
determine
there'll
that
be
you
more
didn't get
income.
all the 1099s,
there'll be
even though
more
they're
income.
covered by the first part, first.
And so I think there'll be more income. That's why it says complete tax returns with 1099s and schedules. It's because we'll find everything out, because there's going to be payments in there as well, possibly, that are non-taxable that still flow through. Essentially, on a K-1, you have distributions versus business income, things of this nature. When we entered into the separation agreement, he worked as a W-2 employee. At the time that we started the modifications, left that job, self-employment on his financial statement. So now I have to go and chase each one of those things to find. And as we've seen throughout, and the record reflects, the amount of contempts that need to be filed to get into compliance with the agreement is more than 10, 14, I believe, at this point, Your Honor. So that's the issue that comes to it. We need to have this because there is 2 underlying contempts and 2 cross modifications, Your Honor, on alimony. Alimony is the ability to pay and the need. We had a self-effectuating order in the separation agreement. That's what it was. It had to go against Ms. Kramer's alimony as well, and that's at, if you look at the record appendix, Your Honor, I believe it's at 57 to 63, and that is the complicated thing, and that's why we had to exchange each year, and it's not just his income statement and the RSUs. All of that stuff was gone because he got a new job, and he went self-employed, and then I had to go in search and try to dig these up, and we had to go to the Discovery Master. And as you see from the April 13th, 2023 order, this financial information was not flowing across. And that's why we've come to this point, and that's why that order was entered. And that's why we have this clear order on the face of it, complete tax returns. Your Honor, I would just like to address that Attorney Dombrowski discussed that there were no formal findings whatsoever on that. I just want to say that he quotes the wrong rule. We're under Rule 52 in the domestic relations procedure, not under the civil rules of 65-3. There don't need to be if it's apparent on the face what's going on. From your comments back to me, I think you've seen what's apparent on the face. We have here, Your Honor, we don't have the tax returns. That's it, and there's a complete
Well,
tax returns.
the language of the rules is similar, but.
It is similar.
But the domestic relations procedure rule says that there's a requirement to find the facts specially and state separately its conclusions of law if the party makes a proper motion.
Under
As-
Tatter
no-
versus-
No motion was made
No
here.
motion was made, Your Honor. Under Tatar versus Schuker, I believe is the case, Your Honor, where you need to have that.
Say
You
that
make
again, I'm sorry.
Tatar versus Schuker. I apologize for the pronunciations.
And am I
Never
correct?
requested an evidentiary hearing either, Your Honor, to then would have to hook those findings in, right? It was all representations of counsel. We do this all the time in probate court, Your Honor. These are representations of counsel because the facts are the facts. They're not going to, either you paid or you didn't pay. Either you produced the tax returns or you didn't.
Final question from me.
Yes, Justice Neyman.
You don't dispute that, and this is reading from the very first paragraph of the settlement agreement under financial disclosures. On or before March 1st, commencing in 2016, each party shall deliver to the other a copy of the W-2s, K-1s, 1099s, et cetera. Are you disputing that that was not provided here?
I don't believe I have all of the 1099s, and that's why I believe the tax returns will show me more income.
I understand you didn't get the full tax returns, but I see. So you're saying we did receive the W-2s, K-1s, we're not sure we have the 1099s or some of the additional information contemplated.
Correct, Your Honor.
Okay. Anything further?
No, thank you.
Okay, thank you very much. Well briefed, well argued. The case is submitted.
Thank you, Your Honor.
Calling our final case, 22P1251, in the matter of Dorothy Keefe. For the record, Attorney Birch will be arguing to us, who submitted a notice of appearance. Thank you, sir.
Good morning, Justices. If it pleases the Court, Austin J. Birch for Mr. John J. Keefe. The issue before the Court is, luckily or perhaps unluckily, much simpler than all of the issues that were heard this morning. We fundamentally believe that the interpretation of 401E gives 30 days to file this affidavit, and that therefore the probate court made a mistake when on July 22nd, 2 days after the filing of that affidavit, the court said, no, let's just hear it now.
So you filed a notice of appearance and objection to the petition here, or your client did. What was the purpose of that notice and objection?
Thank you. So we believed that there are two cases. We didn't believe this. There were two cases that were open. There was an equity case.
Yep.
And this probate case. And we had questions about these accounts that were shared between the mother and the son. And it was, at the last possible moment, there was a change where the son believed he was the beneficiary. Our client believed he was the beneficiary. And
the daughter's husband seemed to have gotten the money, correct?
That's correct.
And that was the subject of the equity action, is that correct?
Yes.
A judgment entered in the equity action. Your client lost in the equity action.
And that is on appeal. And the reason we...
Is that on appeal? My understanding is that you filed a notice of appeal, but have you done anything to pursue that appeal?
As I understood it, we had filed that notice of appeal, and there was some actions we were taking on it. I do not know the answer further than that.
Well, your case is contingent on that, right?
Well, yes, Your Honor.
So I think it's very important for us to know what the status of that appeal is. Number one, is it active? Number two, has it been dismissed? Has anyone pursued it? Has it been perfected?
As I understood it, we had filed to assemble the record on that case and paid the fee to assemble the record on that case.
When? I understand you're in a difficult position appearing today before us for the first time on this case, but you're here, so we have to ask you the same questions we would ask Attorney Milgram. So when was that appeal filed?
If I could check my notes for a minute, maybe. I don't know the answer to that question. I know that I have that. I know that I went to the clerk's office downstairs and I believe paid a check on that case to assemble the record. I don't remember the date off the top of my head.
If that appeal has been dismissed, or if no action has been taken in all of the time since it's been filed to pursue the appeal, would you agree that that is fatal to your case before us today?
Your Honor, I believe that that case, the reason we didn't want to close the probate case was because that equity case was still open and we didn't want to reopen probate. So yes, if that case ends up to be a failure, then it may be dispositive in this case.
Would you agree that it is dispositive of this case because the sole basis that was represented to the court for any remedy on this case is you think that you have money coming to you from the equity action? So it would be dispositive, would you agree?
Yes, it would be dispositive.
Thank you.
If and only if you were to find that there was no error of law and no prejudice in this action before us.
Well, that's the prejudice part, right? If there's no appeal of the equity case, then there's no possible prejudice. You're just holding up the distributions to the wife for no good reason.
Then, in fact, it would be dispositive.
Okay.
So fundamentally,
Assume for purposes of your argument today, by the way, that the judge did make an error. So I think in order to save time, your time, of course, is yours to use as you see fit, but assuming that the judge made an error, the question is, how can you demonstrate prejudice? And I think you've just acknowledged that you demonstrate it through whatever you gain through the equity action. Are you alleging any other form of prejudice?
No, Your Honor. I simply was going to talk about the time limit and the interpretation of 401. We believed at that moment that we had 30 days to answer with this affidavit that would have detailed the prejudice, and then there would have been an opportunity for the judge to hear that.
But you had an opportunity. You had a hearing. You went to a hearing, and it's, again, I wish Attorney Milgram were here, because I'd ask why he didn't talk about the hearing in his brief. But you went to a hearing, and Pauline's counsel says, so there's been an objection, a notice of appearance and objection filed by my brother counsel, and the judge asks, what's the objection, counsel? And Mr. Milgram lays out the objection. So I'm trying to understand what's the possible prejudice of the affidavit issue, because you had a full opportunity to present to the court your objection, and he did.
Respectfully, Your Honor, I would say that we didn't have a full opportunity to present it because it was sprung on us 2 days after we filed it, and to me, it seemed as though
The hearing was on June 22nd, and the judge allowed Pauline's motion to compel, entered the decree in order for a complete settlement on July 18th. So that was another month. You didn't have enough time to file an affidavit in that intervening month to supplement whatever Mr. Milgram said at the hearing?
We filed our objection to the dispersal on the 20th, and then the date was on the 22nd. So we came in saying, this is to us it feels as though that there was a pretrial conference and we moved to trial right on the same day. And fundamentally, we wanted to go home, and we believed at that day that we would get another date and work out the affidavit with our client and come back in and have a full evidentiary hearing. And that's why we were prejudiced on the 22nd when we arrived there, and we were denied the opportunity to have a full hearing on the affidavit and have questions of Mr.
But you didn't, oh, sorry, go ahead.
The representations that were made at the hearing, though, were very simple. It was, Judge, you can't do this because we object, and we need to determine what happens with that equity action before anything else happens.
That's correct, Your Honor.
And in your brief, I don't see any mention whatsoever of how you were prejudiced apart from the pending outcome of the equity action. I understand you have a good argument that there was a violation of a rule of law, but you agree that you must show prejudice to get relief. I don't see an argument apart from the equity action in your brief or before the judge as to any prejudice.
That fundamentally is our argument of the prejudice.
I understand. I just want to make sure of that. Okay.
Well, can you say one more? Why oppose a partial distribution to Pauline? I mean, your whole argument is, well, more money is going to come into the estate, and so we don't want to close things out. But at the hearing, you said the court should take no action on even a partial distribution. Why? What's going on?
Fundamentally, I think that there was, we believe still that the probate will be reopened due to this equity action. And
there's no dispute that she was entitled to the
There is
distributions from the sale of the house.
there's not.
Is interest running on that, out of curiosity?
I believe it's in a money market, according to the record. But
yeah.
Counsel, I'm not going to answer your question. I'll just say that I feel like I'm back in the district court, and I'm on the 12th probable cause hearing date, and the Superior Court DA has done zero and just handed the district court DA the file and said, why don't you stand up and take the shots? So any questions I have, bit piling on, but boy, okay, that's all I have to say about that.
It's not easy being in your shoes, and we appreciate your argument. Is there anything else you'd like to tell us?
I would only say that I believe that there was my sister's motion talks about prejudice and the fact that we didn't file the affidavit and that there was bad faith, and I disagree with those points. I would say that I've already argued that there was, in fact, prejudice to my client, and Your Honors can take that under advisement. Obviously, we did not file the affidavit. Eventually, that is true. When we left the courtroom that day, it was obvious that the judge had already made up her mind, and we had intended to appeal the case at that point. And if it's a requirement that we still file the affidavit while we pursue the appeal,
that is also a decision for your honors. And of course, we believe that we had good faith to make the appeal based on all the arguments that I've made.
I understand that. Just to be clear, though, assuming all of that to be true, nowhere in your brief do you use the word prejudice or allege or delineate any form of prejudice, correct?
I admit that the brief is thin, Your Honor. I thought that both briefs were, could have used some more case law, but I looked and I didn't see a lot of case law on the amount of time that was given on 401E. I believe that at the moment that application was filed, there should have been an automatic stay, and 30 days should have begun to toll, and a additional hearing date should have been scheduled. Everything else, the prejudice comes from the fact that we weren't given the time, that my client was not given the time necessary.
Understood. Appreciate your argument.
Thank
you. And will we hear from Attorney Minchoff?
May it please the court, India Minchoff on behalf of Pauline Toome. I'm also here with my co-counsel, Emma Funnell. I think I would start by asking the court, having just heard some direct questions to my brother counsel before I give a presentation, whether there's any direct questions of me. If there's not, I'm happy to hear myself talk and go into what I had intended to say. But I didn't know if there was any follow-up.
You know the status of the other appeal.
I do.
Why don't you tell us what that is?
Okay.
Pretend we don't know.
The status of the appeal is that this court has dismissed the appeal, the appeals court. In the lower court, there was a pending motion to dismiss the appeal for failure to order the transcripts and certify, more importantly, the transcripts being ordered with respect to the trial and the equity action. So there had been a motion filed in the lower court to dismiss the appeal. This court, however, and I believe, if I'm correct, this is in the last couple of months, this court, maybe even within the last 30 days, this court had issued a dismissal of the appeal after, and I forget what rule it is, you usually give notice of an intent to issue a dismissal before you issue the dismissal. So those procedures happened first, and then a dismissal occurred, effectuated, I believe, on this court's docket.
So the status of the equity action is that the husband prevailed, a judgment entered, a notice of appeal was filed, and that appeal has since been dismissed by the appeals court.
Correct. And I just want to reiterate that at the same time that this court was dismissing, I had a pending motion to dismiss in the lower court, which was somewhat confusing, and I don't want to unravel my own statements here, but I just want to be very forthright that there was this court as well as a pending motion to dismiss that was in the lower court. But if I'm...
Was the notice of appeal filed in the equity action, if you happen to know?
When was it filed?
The notice of appeal in the equity action, when was that filed?
I can get that, or have my colleague get that date
Your
for you,
colleague get it, that would be
Judge, in
fine.
just one second. And as she's getting, I think it's at the very end, as she's getting that date for you, I would like to point out one thing, and I know that there's not much of a record here, relatively speaking, but there is a copy of the transcript from the June, I think, 22nd, 2022 hearing on the motion to compel the distribution, where the court, as this court has noted, asked very specific questions regarding the objections that Mr. Milgram had on behalf of his client. And I just want to note that while that appeal is dismissed, I don't see it standing independently anyways as a ground of prejudice, because Pauline Toome was not a party to the equity action. Only Cornelius Toome. She was never brought in as a party to that action, and you essentially can't say, hey, I want some arguable prejudgment security against somebody who's not a party, who I've never moved to attach or anything like that. So to me, it's irrespective of the status of the appeal, because that couldn't make out prejudice in the first instance.
And you never received a partial distribution, right?
To date.
The money's still sitting in.
My client has not received a partial distribution, and if we look at the equities just from that standpoint, we have Mr. Keefe, who has had his distribution, the property, since I believe, January of 2018. So we're now 6 years out from that point where he's had the enjoyment, and my client hasn't received anything. And we're here actually more than 8 years after the death of Dorothy Keefe, who died in November of 2015, with a probate being opened, I believe, January or March of 2016. So 8 years just from when the probate was opened, 9 years almost from when she passed away. So we're looking at a substantial amount of time, and when we talk about just creating a havoc on the rules, which we're looking for a speedy administration, when there's no, and there's never been, an objection to the terms of this will. The objection back in the day was, I don't want my sister to serve. My client takes a high ground and doesn't take a ground that a lot of people do take in the probate court. I was left PR and I want that role. She said, no. You know, if they want to appoint somebody else, let's streamline this, let's get this done. Have anyone serve, because it's just really a one-asset estate. So she takes that reasonable approach, knowing in the long run that somebody else is going to be paid for a role that she would have been doing free of charge, but says that's okay because I think it's going to cost this estate less money when it all pans out if I just step aside and say, let a court-appointed person do it. And well, whether it's egg in the face or hindsight, however you want to call it, here we are almost 9 years later, maybe rethinking that decision at this point in time, but that's showing that it was just about trying to get it done, and we haven't even done that yet today. And I'm seeing that may I have one moment to perhaps answer the question that was initially asked of me about the docket? I do not have that in the record. I thought it might have been because there was an
You can
equity
look it up
docket,
in
but
the-
it was prior to the notice of appeal being filed, so it's not cited in that docket. I do want to say one more thing, and I'm going to end it with this, and I do want the court to also recognize that, at least from my perspective, when I look at 190B Section 3-1001, I believe that that section also makes clear that a probate court judge, and I think it makes sense as well, a probate court judge they're not limited in making a determination on an account. The requirements are only that notice has been given and that the court docket reflects that the notice has been given to the parties that are to receive notice. But I think it makes it very clear in looking at that statute that the court, with or without motion, can then make a determination on the face of the pleadings as to whether they're going to allow that account. And perhaps not necessary to be said when we actually have a hearing here and we have the objections being articulated at the hearing and a ruling made with respect to those, but I just wanted somewhat as a backdrop to say that statutorily, that's not a requirement for the court. I sometimes learn when not to keep talking, so I'm going to ask the court again whether there's any questions of me, and if there's not, I'm going to say thank you, and I'll rest further on the brief.
Seeing none, thank you both. Appreciate your arguments, and the case is submitted.
Thank you, judges.
That concludes our session.
All rise. This court will stand at recess.